thank you very much for joining us today and contributing to this project. We look forward to your insightful comments and thoughts on our questions. So I'll go right into our first question. Now, the Lagos Court of Arbitration is a well-regarded institution in not just Nigeria, but also Africa, and has been referenced in a lot of articles and, topics on arbitration in Africa. It's well equipped with excellent facilities, but it faces challenges attracting a substantial caseload and high-profile cases. What would you say contributes to this situation?
Thank you very much, Ibuku, for your question. And your question is actually very, very sort of pertinent, and I'll tell you why. When I took over as president of the LCA, one of the things that I immediately saw was that LCA was more or less a venue for the hearing of arbitration proceedings, but not an arbitral institution. And there's nuance there. And so what is the reason? So we had the institution set up quite all right in terms of the physical infrastructure, and sort of taking immediate steps to create the awareness of the institution. But for you to function effectively as an arbitral institution, a lot of things have to be done behind the scenes, long before the disputes come into existence. And what do I mean by that? If we don't have LCA institutional arbitration clauses in our contracts, we will not be able to perform the true mandate of an arbitral institution. So for example, for the LCA, we're trying and we're still trying, to sort of engage with government institutions, particularly Lagos State, using Lagos State as a platform, because that's sort of our captive market, use Lagos State as a sort of platform, have an understanding with the Ministry of Justice that all the government agencies, when they're drafting their agreements and the arbitration clauses, we have our standard LCA clause. So understand the benefits of having institutional arbitration rather than ad hoc arbitration, and I'll be the first person to concede that it's not always every sort of dispute that is suited for institutional arbitration. But, because we have other structures in place in terms of our expedited rules, because we have our small claims procedures, there will still be value in having that the LCA can bring. So from that perspective, you can immediately see that we have a challenge in terms of getting around that hurdle. Because if we don't get around that hurdle, we will just continue, you have your ad hoc arbitration. Oh, LCA has a fine building, let's go there, instead of booking a room in a hotel. But we need to get beyond that. And it's nobody's fault other than that people have to understand that that is the only way that we can build our own local arbitral institutions. Okay. If you put 10 in-house counsel in a room with all of us, and you say, guys, draft an agreement and draft an arbitration clause, I'm sure that 8 out of 10 would put LCA or ICC. Mm-hmm. It's just, it's default, but really their default position should be an LCA or some other arbitral institution in Nigeria, and then let there be pushback and say, oh no, well, this one is an international one or whatever. And then, not the other way around, that we're pulling from an ICC or an LCIA or from a LACIAC in our own environment. Granted that you might be talking about Nigerian companies with international affiliation, but as much as possible, we have to put ourselves out there that we have the infrastructure, we have the personnel, we have the fit for purpose rules, so we really have to be doing that. Now, the second sort of problem that I've seen, and perhaps is not limited to the LCA, but it's a more broader problem in the context of arbitration, certainly domestic arbitration, is that a lot of the players don't realize the initial costs of arbitration. So it's when they start the process, they jump into it. We have this ability of quickly jumping on the bandwagon of something. And then when we get in there, we then realize that, oh, well, it's not so much the bed of roses that we expected. And again, I would always advise, and particularly I always advise young lawyers and in-house counsel, that in as much as we feel that there is a lot that commercial people can get out of ADR, it is not every commercial dispute that is suited for ADR. Because sometimes when I see agreements, a tenancy of 3 million naira or 1.5 million naira, and then you put an arbitration clause. Something that you can just go and do in the magistrate's courts without little or no cost. So in a nutshell, I mean, I can go on and on and on, but those would be like the big ticket points about the challenges that I have seen in my little time at the LCA.
Thank you. I think that's a very good point you make about young lawyers just trying to always consider the nature of a dispute first before deciding whether to take it to arbitration, and understanding what dispute resolution mechanism better suited to actually resolve the dispute. I think it's very important, and probably a lot of trainings and education on that needs to be taught to young lawyers. But I would like to go back to your point about engaging with Lagos State institutions and government agencies, and what their response has been. Because I imagine that for a lot of in-house counsel, particularly the ones with maybe international influence, it may be difficult for them to, propose LCA, or they may propose LCA, but then because of the international influence, they end up settling for ICC or the LCIA. But I believe that, homegrown institutions and agencies should be able to support the LCA. So what has their response been generally, like when you go to engage them and, tell them about the LCA and the sort of services that you can provide?
Good. Again, fantastic point, Ibokun, and that's why I looked at the terrain and I said to myself that I fully understand the challenges that in-house counsel would have in a big multinational, an IOC and all those things. I know that there are some guys from offshore that will say, oh, no. Even though it's another dispute, it's a dispute with a Nigerian company, we need to sort of create that wall between our dispute and the Nigerian judicial system. But having said that, I still believe that in-house counsel, and we really need to, figure out a way of really sitting down with in-house counsel, showing them that we understand some of the challenges that we have, but also letting them know that they still have a lot of power in their hands, especially in-house counsel of big domestics. We have big domestics that, do their business in Nigeria, but still, when you see their contracts, you'll be shocked that you'll be seeing ICC and, I mean, I've been involved in a couple of ICC arbitrations which purely Nigerian companies, but they put in ICC clauses rather than an LCA or some other arbitral institution. So, but the response has been slow, and I'm not blaming anybody. It may be that coming out of COVID and everything, we've not been perhaps as aggressive as we should be in terms of moving this agenda. But the easiest way is always to get the Attorney General of a state to call together all the lawyers in the different ministries and in the different MDAs, get them together and give us an opportunity to sensitize them about the importance of having institutional arbitration rather than ad hoc arbitration. Like I said before, there are some disputes, and educate them about when they feel that, this dispute or this contract that we're negotiating, in the event of a dispute, I think institutional arbitration is better suited than ad hoc arbitration or even mediation or whatever. So it's been slow. We're going to continue. LCA as an organization, they've just sworn in the new Attorney General 2 days ago.
Yes.
So in the coming weeks, we would again reinvigorate our strategy, have a sit down with him, explain what the agenda is, and it's all for Lagos State to have bragging rights. The Lagos State is already riding on the back of the fact that the LCA is in Lagos, and that Lagos is a hub, so we would leverage on that, and hopefully the Attorney General would also be a strong partner in educating the in-house counsel in all those MDAs.
Yeah, I hope so too. Sounds like exciting plans, in motion. So I wish you good luck with that. And now, in light of the AMA's enactment, there has been a lot of excitement from the local and international community, but there's also been a lot of apprehension regarding, the judicial stance and intervention in relation to arbitration in Nigeria. Now, the LCA as an arbitral institution, one of its mandates is to educate, the public. What motions or what initiatives are currently in place for the LCA to engage with the judiciary to sort of explain to them their supportive role and how they can support the arbitral process?
That's a tough question, Ibuku, and tough question in the sense that I've always been of the view, and quite a number of people share this view with me, that we could put in all the necessary structures in terms of legislative intervention, and we rave about our laws being in accordance with international best practices and stuff like that. But ultimately, the success of arbitration in itself as an institution is dependent on judicial attitudes.
All right, you may proceed.
Yeah, so I was just making the point about the importance of the judiciary. Just like I said, in two simple instances, the assistance of the judiciary in terms of ensuring that parties comply with their obligations to arbitrate. Nigerians being what we are, people feel that they can move the goalposts in the middle of the match. And not suffer any consequences. And truly, because there are no consequences, that even if you go to court in derogation of an arbitration agreement, you don't suffer cost on an indemnity basis, for example, for doing that. So people are not really discouraged from doing all those things. And then, at the back end too, we need a strong judiciary when an award has been made and people refuse to comply with the award, but rather they want to, frustrate the entire process. So all those things put together, it's extremely important. In the LCA, in the past, we've been known for our knowledge sharing, continuous legal education, but maybe legal education is not the right expression, but generally we want to not only encourage young arbitrators and train them in a sense, not in the sense like the Chartered Institute of Arbitrators, but train them in the sense of having webinars and workshops on very topical issues that they would experience, and even senior arbitrators. So LCA had, historically been doing that, but COVID threw up a lot of things, that stopped so many things that we're trying to get ourselves back together. And then the current, because we're still in the tailwinds, economically of COVID, so funding and all those things, we're just trying to bring it back to what it was in the past so that we can start all these programs. But specifically, and with the AMA, we feel that, certainly I feel, and I think that it's something that we'll do in the nearest future, is to now start drilling it into our judges, the sort of jurisprudential shift that we need to see in our arbitration law and practice with the new law. A lot of things that they felt that they had discretion to do, it's no longer there. If the parties are deemed it fit to enter into that agreement, they must go and arbitrate, and on the back end, significantly removed the basis upon which a lot of people have engaged in dilatory tactics to set aside awards or argue for non-recognition. So the enforcement mechanism, as it were, has been strengthened. The opaque ground of error of law on the face of the record is hopefully a thing of the past. But we need to drum it into our judges that a whole load of cases of the past are no longer relevant. So they themselves now have to develop a new, tighter jurisprudence on the back of the new law without the shackles of the old regime.
Yes, I agree. Well, thank you very much, Dr. Wale Olawoyin. This was a very interesting discussion, and I'm grateful for all the insights you've shared today. Hi, Ife. Thank you very much for joining us today and agreeing to feature in this project. I know today you'll be speaking as the representative of the Lagos Chamber of Commerce International Arbitration Center, and we're really looking forward to all your interesting points. Now we'll go straight right into it. How do you believe LACIAC, as one of the leading arbitral institutions in Nigeria, can support the implementation of the recently enacted Arbitration and Mediation Act 2023, popularly known as the AMA?
Yeah, thanks so much for your question, Ibuku, and thank you for having me. I think we're at a very crucial time in Nigeria's arbitration history. The Act has, pretty much redefined where we are, what the laws are, and has taken away most of the problems that we saw prior to its enactment. In terms of the implementation, I think there's a lot of work to be done, but in terms of what LACIAC is doing to support this, I would basically put this into three categories. Essentially, we're looking to promote the use of the Act, which is the first one. We're looking to adjust our rules to take advantage of the new mechanisms under the Act. And of course, we're trying to raise awareness about the other mechanisms which we can now incorporate into our processes, which people should know and be aware of, essentially. Now, in terms of promoting its use, my personal view and the view at LACIAC is that there's so much arbitration to be done in Nigeria that's not being done. There's too many commercial disputes in the courtroom, and we're hoping that with the AMA we can promote not just the AMA itself, but the use of arbitration widely and across the board, and that's one of the things we're looking to do. So you're very likely to see webinars, roundtables, and conversations, and just events generally touching on these things. And I'll speak more about that in a bit more detail, specifically much later. The second thing, of course, is adjusting the rules and our guidelines and procedures to take advantage of the Act. And I think the big one, the big example will be the Award Review Tribunal. That's the one that's caught the eye of many people. Now you can see why there's some skepticism as well as excitement. There's really mixed feedback, really mixed views. But what we're trying to do is to take that skepticism, to take what the Act has given us and make the best out of it. So one of the things you're likely to see from the LACIAC ART is that we're trying to cut down some of the major concerns that have been expressed in relation to the ART process. For instance, it's just going to be an extra layer of litigation. Will it take so much more time? And will it cost so much more? So very likely when the guidelines are out, you're likely to see, or when the rules are out rather, you're likely to see a streamlined process that doesn't just adopt what the AMA has given us, but has also, as a matter of fact, made it even more efficient. And I think the final point is we have to make people more aware about the options that exist under the AMA, and put ourselves in a position to offer services and arbitral institution in relation to those new options. And the big one probably is third-party funding. Many parties have LACIAC clauses, not just LACIAC clauses, but clauses referring to other institutions on arbitration generally in their contracts. But when the disputes arise, they say to themselves, it's too expensive, we can't pursue this arbitration because it's too expensive. And what we're trying to do is to let people know the Act now allows you to fund your arbitration claims and arbitration-related claims. And we're going to work up a framework internally to make sure that, primary concerns like conflict of interest, independence, and impartiality are taken care of in line with the third-party funding procedure. And this is not uncommon. We wouldn't be the first to do that. I think the ICC has something similar, and so does the LCIA. Pretty much every major arbitral institution. So in addition to promoting the use of arbitration and the AMA, in addition to adjusting our rules, we're of course looking to make people more aware of the other offerings of the Act and adjusting our internal procedure to take on many of these things and adapt to circumstances when parties explore some of these options, the third-party funding example being obviously the best one.
A lot still needs to be done to get us to that status where we can compete with international arbitral institutions. So what is LACIAC doing in this regard to ensure that, it continues to maintain the status as a thriving one, but also get to the point where it can compete internationally?
I would say very briefly that we need to be tested and tried from a LACIAC perspective, and from a seat perspective as well. We need to be tested and tried. The capacity is here, the laws are here now, thanks to the AMA. The personnel is here, but we need to be tested and tried, and that's the most important thing. And the key into being tested and tried is for the cases to come out of here. The world needs to hear that we're resolving cases by the speed of light. We're resolving cases efficiently, effectively, and if you have an Nigeria-seated arbitration with LACIAC as an institution, that everything will go really well. And it doesn't even have to be Nigerian-seated from a LACIAC perspective. If you have a Nairobi-seated arbitration, if you have a Kampala-seated arbitration, if you have a Johannesburg-seated arbitration, if you have a Kigali-seated arbitration, you could also resort to LACIAC arbitration. For us, it's a matter of being tested and tried, and we're trying as much as possible to increase caseload, to get people to use arbitration a lot more. This is the entire push right now, and if you've probably noticed from our social media pages, we've signed MOUs with various arbitral institutions across the world, just to build that connection and network of people, just to help promote what we do, to collaborate in bringing about a bigger caseload for LACIAC. So that's really the first step. And I would say for us internally, what is perhaps more important to us at this stage to develop that caseload is to build credibility across sectors, across the business community, first of all in Nigeria, obviously, this is where we are based, but also in other countries across Africa and hopefully beyond. Because at some point, the demand is going to go up for an institution on the continent that can handle the disputes. And we need to be, top of mind in this regard. So building credibility is perhaps the most important thing for LACIAC, credibility amongst within the business community, and just leveraging that credibility to build our caseload. And obviously, then the ball falls entirely within our courts to do an efficient and effective job. And we have obviously a host of practitioners, top practitioners from across the country, across the continent, across the world really, who sit on the LACIAC courts, who sit on the LACIAC board, who of course are willing to lend their experience and expertise to ensure that the institution is run the way an institution should be run. And obviously in a matter of hopefully years, we can say that we are the standout institution from the country, from the continent, and that we are able to offer what global institutions can offer. And like we always say, there's this room in the sky for all the stars to shine. So it's really necessary for Nigeria as a seat for all the institutions to be firing on all cylinders, and we intend to take the lead in that regard.
All right. Thank you so much, Efe. This was a really great interview, and we appreciate you for sharing your views. Thank you very much.
Thank you.
I think that the world progresses by people solving hard problems.